All right, welcome back, everyone. So in our first video about structural justice theories, that one covered Sally Haslanger, we looked at both her explanation of what a structure is and her argument about when structures become unjust, structural justice, an explanatory and a normative side to her argument, to which we saw some objections both to the structural explanation and to its normative claims. What I want to do now is show you the ways in which Iris Marion Young and Kimberly Crenshaw would offer a different set of suggestions than Haslanger about what to do about structural injustice. And in seeing that, we'll see different answers to the two objections that we looked at last time as well. One, we'll see a different explanation of structures that gives more autonomy to moral actors within institutions. And two, a more specific normative argument about the wrong-making features in structures. We've already seen various suggestions that have been made about what we should do about structural injustice. One method of social change preferred by linguistic structuralists is language change itself. We saw that in our Before the Basics video. Their idea is get people to stop saying X or Y, and perhaps you'll get them to stop engaging in the unjust practices around X or Y. We also saw in that video another method put forward by other social structuralists like Frantz Fanon, and that's violence. Fanon had suggested that since the imposition of structural roles and meanings by the powerful, like colonizers do this, colonized do that, since he said that relies on a kind of epistemic violence, then the only remedy for it is violence. But Haslanger rejects both of these views. In a YouTube video I provided on Canvas, a talk she gave at the very prestigious Royal Society of Philosophy, she says that what she calls individual acts of resistance, like changing what you say or do, are unlikely to be effective. And she doesn't believe that violence is the only option for change, even of social structures that she says land upon the body with violence. She really dismisses out of hand her critics who accuse her of that. And for good measure, she says that institutional changes in laws and policy, are also unlikely to help because systems, she says, have a way of canceling out any perturbations in practices and then reproducing the same results as before. So, what will work? She says, disruptive social movements. Here she quotes Elizabeth Anderson, a famous philosopher at the University of Michigan. Between pure argument and violence, you might think of that as between a philosopher and Fanon, there are a wide range of contentious activities that are more or less disruptive of habitual ways of life. Philosophy, or reason-giving, won't change structures, but it's not necessary to go all the way to violence. You can use disruptive social movements, she's saying. But a lot of people find that suggestion unsatisfying and quite vague. So a number of structural justice theorists have turned back to the work of Iris Marion Young for another answer about remedies for structural injustice. Just a little aside here. Why do I say back? Well, Young died prematurely at the age of about 57, though she was the same age as Kimberly Crenshaw and only a bit older than Haslanger. So they're moving back in the sense that they're going back to a work from the 1990s by a beloved colleague of theirs. Young proposes institutional fixes to structural injustices in her book that's called Justice and the Politics of Difference. In particular, she proposes discourse rather than disruption. A change to democratic laws and practices could perhaps remedy the wrongs of structures. And she makes it clear that the basis of her condemnation, that is, the wrong-making features of structures, begins from certain normative elements that are connected to classical theories of ethics. Although her judgment doesn't end there, she begins from some concepts that she takes from some of these theories. Now, one thing she rejects out of hand about the classical theories is their focus on the distribution of material goods, rights, and opportunities in society. Justice is not simply distributive, she says. She says from pages 16 to 18 that the problem with the distributive model is that it's based on some idea that we can treat people neutrally or impartially, and that we can distribute goods, rights, educational opportunities, job opportunities in some way that treats them all the same, regardless of race, gender, class, and so on. So the classic theory's response to finding, say, inequality between white men and white women in the workplace, or white men and black men in society at large, would be to say that the gender and the race discrimination has to stop. We have to start treating people impartially. A principle of equality would be invoked to say we should treat all people in a disinterested way and distribute to them only based on neutral characteristics. But the structural response is to say no. There is no such abstract person who can be thought of apart from their gender or race. Everything they do, every opportunity open to them, is going to be conditioned by gender and race. So the object of critique can't be reaching some impartial or neutral treatment of individuals. The object has to be justice towards people in the structural roles they are in, as women, as members of minoritized group, as members of classes. Otherwise, you can't criticize the very structures that produce and reproduce them as disadvantaged subjects. Take, for instance, the structure of work, which she addresses on page 20 to 21. If our only concern is whether white women or black men get the job, we'd be missing that work itself places them in a power structure. So a classical ethical theorist can only criticize an unfairness in getting the job, not that the job itself, a supposed opportunity, might be another side of injustice, domination, oppression. Jobs have hierarchies, after all. So, and this is important, Young says that social justice can't be achieved merely by looking at unfair patterns of distribution of goods or rights or opportunities, and then pretending that the distribution just would be just if we simply treated everyone impartially as individuals. We have to look at the specific conditions they are in as the people they are and assess those conditions. She says in Justice and the Politics of Difference, in the excerpt that's on Canvas, page 15, I suggest that social justice means the elimination of institutionalized domination and oppression. Any aspect of social organization and practice relevant to domination and oppression is in principle subject to evaluation by ideals of justice. So Young wants a theory according to which it is not simply the actions of moral agents upon moral patients that is in principle subject to evaluation, but any structure which creates domination or oppression. And you notice that she's using justice related to the classical theories to judge our social life, but she's greatly expanding the aspects of social life that she would judge. All structures now fall under an analysis based on justice. For her, domination and oppression can be defined to connect them to the classical theories and democratic theories too. She defines those terms on page 16. Domination, for Young, occurs when there are institutional conditions that inhibit people from participating in determining their actions, or even participating in determining the conditions for their actions. Participating is a key word here. She's not operating on the deontological premise that full autonomy is possible, and she's obviously not going full structuralist, saying that our very sense of the options available to us is already determined by the meanings we use. She just says that people have to participate in setting the conditions that determine their actions. We don't have to smash the structures to be free. It's enough to say that we, by participating in determining larger social structures, participated in determining our own actions as well. Oppression occurs, she says, when there are institutional conditions that keep people from learning about their own skills and abilities and using their expanded skill set in social settings. Think, just for an example of one of those skills or abilities, about the skill of being a good orator in political meetings, which would be necessary for that participation that we just saw her talking about. You could also think of another example, because she says that oppression occurs when we can't play or communicate with each other as well, two skills she talks about. If we couldn't do those things, then we couldn't form social connections and tell others our perspectives on the structures that we're forming together. Now, I want to emphasize again that at the very least, Young still thinks justice is a useful norm for assessing distribution, but what's hugely important is to notice how she differs from the older theories on how we would reason about that thing she calls justice, where some utilitarians would say it's enough for an individual to reason about the good from the perspective of a disinterested and benevolent spectator, and where Kant or other deontologists said we, as individuals, reason about our duties from the perspective of a kingdom of ends, discerning the duties that we owe to all other human beings without preference to anyone. Young says we have to think about justice in ways that are not individualistic and impartial, but dialogical and partial. Partial here doesn't mean incomplete, but particular to you. Your view will be situated where you are, in the structures you are in, and partial to you. But that's fine. It's good even. She says on page 105 of what you read that moral reason does require fair reasoning in the sense of taking, she says, some distance from one's immediate impulses, intuitions, desires, and interests in order to consider their relation to the demands of others. But that doesn't mean for her impartiality. It means respecting the fact that your reasoning and that of all others you owe justice to will be partial, and that's okay. We'll only know how our treatment affects others if we hear them make their partial claims. And she says on page 106 that our reasoning about justice has to be dialogic, too. She says it has to be the product of discussion among differently situated subjects, all of whom desire recognition and acknowledgement from the others. There is no need for a universal point of view to pull people out of egoism. Of course, this sort of dialogue is only possible if people from within their own situated standpoints can understand people who speak from within others. So a strict standpoint epistemology couldn't be true. Discourse still has to be possible. Young says that partial discourse is possible, in fact, even in the context of heterogeneity. While discourse can't be impartial in the sense that we come to comprehend all relevant viewpoints all at once, it nevertheless is discourse or communication between people, which has got to mean that they're comprehending at least some other relevant perspectives, partial as they are. Now, Kimberly Crenshaw's claims overlap with Young's on these issues of impartiality or neutrality. For example, on page 151 of the article on Canvas, Demarginalizing the Intersection of Race and Sex, she says that she's against the liberal ideal that you could be neutral with respect to race or sex. She tells the story of various court cases in which black women who live at the intersection of a disadvantaged race and a disadvantaged sex have tried to make claims under anti-discrimination law. They say that there's something worse about how they are being treated in hiring and in the workplace than white women, and something worse in how they are treated than black men. They say that the discrimination they experience is at the intersection of race and sex. But as Crenshaw shows, they are repeatedly rebuffed by judges. Well, then she concludes that there is an unjust structure in place, and it is precisely anti-discrimination law which is that structure. See page 140 of the article for her claims about this. The problem doesn't have to be racist individual employers who discriminate one by one. It doesn't have to be racist judges that fail to protect black women by misapplying the law. What if it is those anti-discrimination laws themselves that have the effect of excluding intersectional claims? The very meanings encoded in the law, well-intentioned meanings, which however produce bad effects, are holding back black women, she says. The intention honestly doesn't matter. The effect shows that the meanings encoded within this structure discriminate intersectionally. And indeed, you see Crenshaw make the claim that it's not just the law that pits black women against white women and black women against black men. The entire context of employment, which people need to hang on to for survival, the entire context of employment raises the stakes and divides the interests of marginalized people against each other. So you see her on page 145 make another claim that resonates with Young. Crenshaw says, as long as anti-discrimination doctrine proceeds from the premise that employment systems need only minor adjustments, opportunities for advancement by disadvantaged employees will be limited. Relatively privileged employees, and you'll see in the context of the article what she means here is white women and black men, relatively privileged employees probably are better off guarding their advantage while jockeying against others to gain more. And you would see in the context of the article, the others that they're jockeying against are black women. Let me just give you one example of a case that she says pitted disadvantaged people against each other. DeGraff and Reed versus General Motors. It's from 1976, and she covers it on page 141 to 143 of the article. Before the 1960s, General Motors simply didn't hire black women. At that point, which is also the point of the adoption of the Civil Rights Act, they started. But within a decade, a major recession had hit. GM had a seniority rule, which meant that the people with the longest time in the workforce were most protected. And obviously, people who'd been there since the 1940s, let's say, were disproportionately white men. Working men hired since the 1950s, perhaps proportionally more black. Women in secretarial jobs, proportionately more white since the 1960s at least, but black women had been hired in just the past few years. So GM started to lay people off, and applying their seniority rule, literally every black woman hired from 1970 onwards was fired. Last in, first out, as they say. GM would say that this was because of the seniority rule. So this decision was just a neutral application of a rule. But Crenshaw would say, looking at the structures of employment that led to the pattern of black women being the last in, she'd say there's structural discrimination against black women here. The layoffs didn't seem to disproportionately burden women. There were a lot of white women with seniority. And they didn't seem to disproportionately burden blacks. There were a lot of black men with seniority. But the court refused to combine the two groups to look at discrimination against black women in particular. The layoffs disproportionately hit that group, but the court refused to look at the intersection of race and sex. Crenshaw on page 151 likens this to a basement in which all of the disadvantaged people are stacked on top of each other trying to climb out. For white women and black men to get out, to experience non-discrimination, they have to stand on black women who are more disadvantaged than them. The marginalized, she is saying, should not be pitted against each other. That is structural injustice.